You can see that they could feel for the person stood in the dock telling their story of what happened, because that could be them. And probably most of them are drivers.
Found not guilty of death by dangerous driving, the driver received one of the lowest possible sentences for death by careless driving, 240 hours community service and a year's driving ban. The judge concluded the collision had been due to momentary inattention.
From the moment the jury said not guilty, I think we were more and more let down from there. And mainly by the judge, I suppose, because I certainly wouldn't want to be on the roads with anybody that classes that as just careless.
Solicitor Paul Kitson works at one of the UK's largest law firms and has vast experience in pursuing civil fatal accident claims.
The difference between death by careless driving and death by dangerous driving is that within careless cases, the standard of driving falls below a careful and competent driver, whereas for dangerous driving, the standard falls far below that of a careful and competent driver. What is meant by far below is not particularly clear, and there is, I think, much confusion with the judiciary about where that dividing line falls.
Before 2008, momentary lapses in concentration which resulted in death were generally charged as careless driving, which doesn't carry a custodial sentence. The new law causing death by careless driving carries a maximum 5 years sentence.
There was a gap in the law and it needed to be filled. The trouble is that that gap in the law has been used to capture cases that ought to be dangerous driving cases.
According to road safety charity Break, the new law is failing to deliver justice.
We are seeing time and time again families who are already traumatised and grieving as a result of being bereaved or seriously injured in a road crash, feeling grossly let down, and their pain added to by what goes on within the criminal justice system.
So is the careless driving law being used to deal with dangerous drivers? In the last year before the new charge was brought in, 233 people were convicted of causing death by dangerous driving. In 2013, a total of 310 people were convicted of causing death by dangerous or careless driving. So that means that more people were held to account for killing from behind the wheel. However, of those convictions, only 109 were convicted of death by dangerous driving. That means since the new charge was made available to prosecutors, convictions for the more serious charge fell by 53%. So what's behind this startling fall?
What we're seeing is plea bargaining happening, where motorists are accepting a plea for death by careless driving, and they are contesting the dangerous driving charge. In many cases, the dangerous driving charges are dropped if there's a guilty plea entered for careless driving, and if the case does go to court, the judges themselves are slow to make strong jury recommendations or directions to convict for the dangerous driving charge.
In a statement, the Crown Prosecution Service told Panorama,
"We must now consider which of two death by driving offences is the most appropriate, and it is therefore inevitable that these cases are now split between the two options. We determine the most appropriate charge on the evidence alone. We are confident that cases are charged appropriately."
Getting the charge right is not the only problem. When it comes to causing death by careless driving, there are concerns that the sentence doesn't always reflect the severity of the crime. "72-year-old Brian Pattinson from County Durham had an impeccable driving record.
Dad was a really careful driver because his oldest son, Tony, was killed on the road when he was very young. He was about 3 or 4, and that made Dad really aware of how dangerous the roads can be.
On the 17th of July 2012, Brian's car